All right, welcome. For people who are sitting in the back, unless you're sitting in the back because you don't want to be in any pictures in that side section, it'd be great if you move forward. There's a lot of empty seats in the front. I know nobody likes to sit in the front, but actually it's really good for learning and for many things. Oh, is the microphone? Okay, better. Okay, well, anyway, if you want to move down, you're welcome to. For those just joining, I'm Deborah Satz, and I'm the instructor for the class, along with Paul Brest. Our Kaisa Goodman serves as our teaching fellow, and we also have a section this year in addition to the lectures. So I'm just going to quickly recap for those who are new to the course what we're trying to do, and then my colleague Paul Brest will come up for a moment, and then I'll introduce the topic and I'll come back up and introduce the topic and the speakers. The barcode will go up, so for those students who are enrolled in the class, if you can sign in, that'd be great. So what's the class about? Well, deep disagreement pervades democracy, from arguments about immigration, taxation, foreign policy, reparations, the Middle East crisis, to the function of elite higher education and the value of free speech itself. Such disagreement is not by itself a cause for concern, and part of what our aim is to show how and why disagreement is not a bug, but a feature of a democratic society. That is, that we should expect in a democratic society where people are free to gather information, to have different kinds of experiences, where the world is complex, reasonable people trying to find an agreement will still find it hard at times to agree. And that's a fact that we have to live with. And so we want to help illuminate that fact. Now, not all disagreement is productive and reasonable. So part of the aim of this course is to model respectful, evidence-based disagreement and to really delve into why is it that on some very hard issues that concern all of us, there is disagreement that persists, to see what we might do about it, to figure out how we ourselves come out on the issues, and to remain open-minded to consideration of the views that are different. One of the things that the course is also trying to model is what we call civil disagreement. And I think it's important to note here that by civil, we don't mean polite, although we expect our speakers will be polite to one another. That's not what we mean by civil. We mean respectful, taking the ideas seriously, taking the person seriously, and doing and not treating people with disrespect simply because they hold different views than we do. And with that, I'm going to give Paul a chance to say a few things, and then I'll introduce today's subject and speakers.
If you wonder why Deborah and I are repeating our introductory statements, albeit in a shorter format, it's because in addition to those of you who are enrolled in the course, there's sort of a shifting group of auditors, and we thought it would be a good idea for them to understand, as well as to reiterate for others, what the underlying motives of the course are. Deborah explained that disagreement is essential to the maintenance of democratic institutions. And as I did last week, I'd like to quote from a recent article by an opinion writer in the New York Times, and all of what follows is a quote. "Whenever somebody agrees wholeheartedly with something I write, I die a little inside. I know opinion columnists are supposed to be in the persuasion business, and that makes agreement the coin of the realm, but instant knee-jerk agreement makes me suspicious. The coin is devalued. Yes, I'm happy if you appreciated my columns, but please don't give me an absolutely or nailed it, let alone straight fire. I want a straight douse, straight fires. And please never respond with 100%. I'll take principled dissent, thoughtful counter-argument, even enthusiastic over 100%. If you act to something I've said or written with 100%, all you're doing is telling me that I probably did not persuade you of anything. Instead of changing your mind, I simply affirmed your thinking. 100%, really? Even if you agreed in the main, did you find nothing at all worthy of disagreement? Not even, say, 3 to 5%? If so, why should I bother writing, and why would you bother reading? 100% agreement is a high percentage failure rate. Well, I don't think 100% agreement will be a problem in this course or with today's topic. So just two logistical matters before Deborah introduces the guests. First of all, if you're taking the course for 2 units, which means you're also in one of the discussion seminars, and you haven't heard from Kaisa, either see her after this class or send her an email. And then we're going to proceed each week's conversation with a poll on the relevant question. And let's put the poll up. And you'll get a chance now to register your views on this question, and then afterwards. And of course, what conclusions you draw from the different results, if they differ, is completely up to you, but maybe it'll provide some food for thought for the class.
Great, thanks. Okay. All right, so can you hear me? Okay, microphone is funny, funny distance away. So free expression serves important ends for us as individuals and for society, but it's not unlimited. There are boundaries to free speech that are not disputed. We have laws against libel, government regulates consumer product information, and no one thinks you should be able to gratuitously yell fire in the proverbially crowded theater. So we cabin off certain moments of speech as not protected. The question that we're going to be looking at today, and that you see on the screen, is what about hate speech? Speech that aims to defame, insult, or deprecate the dignity of members of certain groups. Should hate speech be protected by the First Amendment? Or should it somehow be cabined off or treated differently than that speech that is protected? To help us think about these questions, we have 2 excellent speakers. Nico Perino, who will be speaking first, is the executive president of FIRE, which stands for FIRE, F-I-R-E, the Foundation for Individual Rights and Free Expression, one of the very important free speech organizations, particularly focused on college campuses, but not only. He's the host of FIRE's So to Speak, the free speech podcast, and trained in journalism. He's previously worked in the communications department at the Institute for Justice and has written extensively about free speech and civil liberties in places like the LA Times, the Boston Globe, the Guardian, and Politico. He's also directed or consulted on several free speech-related films, including Can We Take a Joke?, a film about censorship in stand-up comedy, and The Mighty Ira, about the career of the former ACLU director Ira Glasser. Jeremy Waldron is professor of law at NYU School of Law. He's written extensively and originally on topics in political and legal theory, including not only hate speech, but also judicial review, theories of rights, the work of John Locke, theories of property, and theories of democracy. He's written or edited 17 books and written more chapters than I can easily count. His books include The Harm in Hate Speech, which is, you've read an excerpt for today, and One Another's Equals, The Basis of Human Equality. So now join me in welcoming Nico Perino, who'll be our first speaker.
Thank you so much. It's a pleasure to be here. It's the first time I've ever been at Stanford, and I don't think I've ever seen as many bikes and scooters as I have here at Stanford. I think I dodged 3 or 4 and almost ended up in the hospital, but I'm glad I didn't. I'm glad I'm here with you all today to talk about the lighthearted subject of hate speech. I want to begin by saying that I oppose hate speech. Now, I think there are challenges with defining what hate speech is, but I have 2 young sons at home. I've got another on the way, and I don't want to raise them to use vile, hateful invective against others. I don't think it's the right way to treat people, and I don't think it's the right way to win an argument. Now, at the same time, I also oppose hate speech regulation, particularly when the regulation comes from government. Now, there are many reasons why I oppose hate speech regulation. Many of them are addressed by Professor Waldron in his excellent book, The Harm in Hate Speech, which I had the opportunity to reread this past weekend. Some of those reasons include the fact that I believe it is a violation of individual autonomy, the right for each and every one of us to be who we are and to speak our minds. I believe it undermines democratic legitimacy, the idea being that in a democracy, you'll only trust the outcome of the democratic process if you think that process itself is fair. And the ability of each and every one of us to voice our opinions, I think, is one way that we ensure fairness, or at least the perception of fairness in a democracy. I also think that free speech, allowing for even hateful speech, helps us to know the world as it actually is and not as we wish it to be. My friend, the writer Jonathan Rauch, says that banning hate speech is like breaking the thermometer. You don't know what the temperature is anymore, but the temperature is still there. But I want to focus my introductory remarks on another reason why I oppose hate speech regulation. And it's a simple one. The previous ones were more philosophical, more grand. I believe hate speech regulation is bad politics. It's bad political strategy. If you're a vulnerable minority, particularly one that is oppressed by the government, the last thing you should want to do is give those in power more authority to police the expression of opinion. I've spent my entire career at FIRE, for the most part, 13 years now, and throughout that entire career, I've seen the use of hate speech codes, and they're not often called hate speech codes. Sometimes they're called anti-discrimination codes or acceptable use policies here on a college campus, or an anti-harassment code. But I've seen them used to target political dissenters, scholars, artists, activists, journalists, people who cut against the grain in any given community. But because we're on a campus today, I want to focus on a few, or at least begin with a few campus examples from my career. In 2021 at Emerson College in Boston, there was a student group that was handing out some stickers that said, "China kinda sus." Sus, I guess, is young person slang for suspicious. And they were handing out these stickers to protest what they saw as China's involvement in the COVID pandemic. But some people complained that these stickers themselves were discriminatory against Chinese students. Indeed, the president of the university sent out a community-wide email that accused the student group, because they were handing out these stickers, of anti-Asian bigotry and hate. The student group was suspended and its charter was later revoked. Now, the student group itself was a third Asian, and one of the students who was handing out the stickers was herself Asian. But nevertheless, they had their charter revoked. There's also the case at Hamline University in Minnesota, where a professor, Erica Lopez Prater, taught a global art history survey course. And one of the sessions of that course was on the Middle East. And as a part of that course, she showed a famous 14th century painting that included a depiction of the Prophet Muhammad. Now, in some Islamic traditions, you can't look at the Prophet Muhammad. So she, knowing this, gave students a warning ahead of the class and said, hey, I'm going to give you a warning when this image comes up. You don't have to participate or look, or you can even skip the class if you want to. One Muslim student ignored or refused to listen to this warning, attended, and then complained to the university administration. The university administration accused the professor of Islamophobia, and she was fired. Now, maybe you think those are appropriate applications of hate speech policies. Or maybe you're like me and think they're not, and that they curb discourse and discussion and are violations of academic freedom. Nevertheless, smart people write these policies, right? And if smart people write these policies in a way that they can be abused, it calls into question this whole concept of hate speech regulation. Professor Waldron, in his book, The Harm in Hate Speech, points to the regulations in places like Canada, New Zealand, the United Kingdom, Denmark, as examples of the sort of hate speech regulation that he supports. I want to read some of these regulations, and I'm pulling them from Professor Waldron's book. Denmark's code prohibits statements by which a group of people are threatened, derided, or degraded because of their race, color of skin, or national or ethnic background. Germany's code targets speech that insults or maliciously maligns segments of the population. Derisive, degrading, insults, and maligns, these are the sort of slippery words that throughout my career I've seen used by those in power to target speech that they disapprove of. Even within these countries, I've seen what I seem to think are abuses of these codes. Just last year in the United Kingdom, there was a big trial over this pro-Palestinian protester who brought a sign to a pro-Palestinian protest that depicted Rishi Sunak and Suella Braverman, the then Prime Minister, and Home Secretary, as coconuts. The idea brown on the outside, white on the inside. The idea being that there were traitors to minorities. Well, she was brought up on charges of a racially aggravated public order offense. She was eventually acquitted, but outside her trial, 5 protesters protesting her prosecution brought coconuts and were themselves arrested. The question that we must ask ourselves is, who do you trust with the power to police the expression of opinion? Who do you trust with the power to determine what is derisive, what is degrading, what is insulting, or what is maligning? Joe Biden? Donald Trump? I often talk to students on college campuses who want a speech code, but also believe that their administration is oppressive in some way. This has me scratching my head and wondering, who do you think is going to implement this speech code? Again, time and time I've seen college administrators use hate speech codes to target political dissenters on campus. A Zionist student organization in the United Kingdom in the 1970s learned this the hard way when they supported a racist hate speech code in that country. The code itself was being proposed by the National Union of Students in response to a rise in anti-Semitism and fascist speech on campus. And again, the Zionist students supported it. Well, a year or two later, that same code was used to ban an Israeli ambassador from speaking on campus. An outcome, I should say, that the National Front, a fascist organization, supported. They later got rid of the code for reasons such as this. But you can see how these codes can be abused. My mentor, Ira Glasser, who I made a documentary about, Mighty Ira, former executive director of the ACLU, likened speech restrictions, particularly hate speech restrictions, to poison gas. They seem like a great idea when you have the enemy in your sights and the wind at your back, but the wind has a way of shifting. Now, before I turn the microphone over, there are 2 things that I want to say in framing up our conversation today, and I do hope it's a conversation and as many of you as possible are able to participate. I am not a free speech absolutist. I actually haven't met anyone who is. There are people who say they're free speech absolutists, but then when you get down into it, they always have their exceptions. I believe that categorical exceptions to free speech, like true threats and speech integral to criminal conduct, are thoughtful exceptions to the First Amendment. I should note also that hate speech isn't a categorical exception to the First Amendment articulated by the Supreme Court. So I'm not a free speech absolutist. But I am what my colleague Greg Lukianoff calls an opinion absolutist. I believe there should be near universal protection for the expression of people's opinions. Now, in this way, my view of free speech isn't perfectly aligned with the Supreme Court, so I hope I don't have to hold water for the Supreme Court today. There are categories of unprotected speech like fighting words and obscenity that I think veer too close to the prohibition on the expression of opinion. I should say fighting words was actually the justification that was used by Stanford for its hate speech code in the 1990s, and perhaps we can discuss that it was struck down under the Leonard Law, which itself is this weird law that California has applying First Amendment standards to private non-sectarian colleges and universities, something I'm not too keen on, but again, we can perhaps discuss. For me, the key distinction in determining what speech should be protected and what speech shouldn't be protected is whether it is core speech or whether it is conduct or action. Now, I know Professor Waldron from his book thinks this distinction is a little bit blurry, and maybe it is, I don't know. Maybe it's a pure fiction, but I believe it's a civilizational distinction. I agree with Sigmund Freud, who said that civilization was started the day man first cast a word instead of a stone. And it's for that reason that I oppose hate speech regulation. Thank you.
Good afternoon. I'm Jeremy Waldron. I wanted to thank Nico for that good introduction to our topic, and to thank Deborah and Paul for inviting us both to be here today, to thank you for coming along, and I look forward to engaging with you and with your questions. So we have a couple of issues to address today. One we've already had an excellent introduction to, which is the relationship at a rather abstract level between free speech and the idea of hate speech and the idea of hate speech regulations. The other issue that I think has been disclosed by recent events has to do specifically with how these play out on campus. And more than that, how they play out when our attention is focused on the recent protests about the war in Gaza, the encampments that were set up in some urban campuses, the setting up of blockades and blockages to prevent students from freely moving around the campus, and the disfigurement of the debates that take place in university campuses by chanting and by forms of engagement that don't allow what we're allowing here today, which is some sort of relationship between interlocutors. So I want us to think a little bit about the particular issues as well as the general issues. I think it's probably important to talk about both and to test our broad intuitions about free speech and hate speech regulation and what should be protected and what shouldn't be protected against particular settings where those issues become particularly acute. It's not just academic settings, it's also things like church services, funeral services. You remember the case of Snyder against Phelps from 2011, where there was an attempt to defame and to degrade and insult, to use those words that Nico pulled out of some of the German hate speech laws. There was an attempt at a funeral in the United States to inflict emotional distress on the mourners at the funeral. And the suggestion was that that couldn't be held accountable under the tort of intentional infliction of emotional distress because of the speech element. It was speech, not anything other than speech. Justice Alito, bless his soul, was the only dissenter in that decision. So there are questions about that particular sort of setting. There are questions about what we should allow, what we should expect in workplaces. And one of the things that I'm greatly indebted to my colleague Nico for bringing to our attention today are the issues of civil rights law as they apply both to university settings in Title VI and workplace settings, Title VII. We have to think not only about the general relationship between hate speech and First Amendment values, but we have to think about how that tension, that standoff between the two of them plays out in particular focused settings. So I really do want us to work on that double front so that we make sure that what we are prepared to say about hate speech and free speech can actually make sense as a strategy for addressing what's at stake in these particular settings. It's kind of a difference between wholesale and retail, which is one of my favorite philosophical distinctions. But I do think that the abstract issue is as important as Nico mentions. We know that despite the plausibility of the arguments that Nico made, and that have been made over and over again by the ACLU and by civil liberties proponents, that the United States is and remains an outlier on the issue of hate speech. Most countries, or many countries, Canada, Israel, all the ones that Nico mentioned, Great Britain, New Zealand, where I come from, Denmark, France, Germany, these countries all have hate speech laws, have had them for many, many years indeed. And I wanted to say a little bit about the overall shape and character of those laws, and a little bit also about the purpose of the laws. I think Nico talked about the vocabulary of the laws and the terminology that tends to get used in them. But let's just go back step by step and think about how the notion of hatred plays into hate speech laws. It's not a matter of the speech being speech that we hate, although Anthony Lewis wrote a wonderful book called Freedom for the Thought That We Hate, and people have sometimes talked about the speech that we hate as being hate speech. Hatred doesn't enter into the discussion in that way. And we're not necessarily talking about speech that is born of hatred, speech that is caused by hatred, speech that is an expression of hatred. Although that may be an important category for psychological reasons, it's not what hate speech legislation tries to get at. Almost all the countries that we have mentioned, which have hate speech regulations, are particularly concerned with speech that is calculated and intended to stir up hatred in a community, to stir up hatred against a particular subset of the members of that community, a particular section of that community, that is intended or could reasonably be understood to stir up hatred and to make it harder for the members of that community to survive or to live or to conduct their business or to raise a family in an environment that has been polluted by the attempt to secure some degree of hostility in a community. So that's the first thing to notice about the architecture or the structure of hate speech laws. Most of them say that it's an offense to use speech or to publish anything that will stir up hatred against other groups. But they don't stop there. Most of the hate speech regulations indicate that they want to focus a little bit on adverbs that might be applied to the speech acts that they are considering. And that's what I had in mind when I said that there's no real distinction between speech and action. There are such things as speech acts. What I'm doing now is an action, but it's also a speech. The speech acts have to be done in an abusive, insulting, and threatening manner. So there's a suggestion that you have a safe haven for your criticisms, for the expression of your opinions, if you can make the case that your opinion was expressed moderately, reasonably, in a way that wasn't abusive, in a way that wasn't insulting. So there's that second element. And the third element is a suggestion that we want to make sure that certain forms of speech are not wrongly categorized as hate speech. So in section 29J of the British hate speech legislation and the Racial and Religious Freedom Discrimination Act, there's a suggestion: nothing in this part of the Act shall be read or given effect in a way which prohibits or restricts discussion, criticism, or expressions of antipathy, dislike, ridicule, insult or abuse of particular religions or the beliefs and practices of their adherents or of any other belief system, or to proselytize or urge adherents of a different religion to cease practicing their religion or belief system. So there's a specific clause there which attempts to make sure that they're worried about people stirring up hatred against the believers of a religion rather than stirring up hatred or satire or abuse of the tenets or the propositions believed in the religion. So there tends to be that element of the structure as well. And finally, the other thing I wanted to say about the structure of hate speech legislation is that there are often restrictions on who can bring prosecutions. Nico raised this really important question of who do you trust to enforce these provisions? Who do you entrust to make the hard decisions? In some countries, Great Britain, again, is a good example. A prosecution by the state for hate speech has to be approved in advance by the Attorney General. And the Attorney General, when he or she is making that decision, is exercising a non-political power and has to make a judgment about whether the public good demands this. So just think about these features of the structure of hate speech laws, that they tend to be focused on stirring up hatred, not just expressing hatred. They tend to be focused on particular forms or particular modes of stirring up hatred, and they often have various exemptions and safeguards built into them. I want to make that point primarily so that we understand what we're talking about, even when we oppose hate speech regulation, because an awful lot of people have some misapprehensions about it. But this is not so far to persuade you that we should have hate speech legislation. To do that, I would probably want to mention a little bit about the overall purpose or policy of such hate speech legislation. And here I want to mention the fact that they are often concerned with defamation of a group. They're often concerned with group defamation. They're often concerned with attempts to besmirch or cast aspersions on the reputation of the members of a group, understood in relation to their membership of the group, and often understood as ways of making sure that it is well known in the community that their reputation has been besmirched in this way, and that people react to them and will respond to them as if the reputational slur or the reputational aspersion were to be taken seriously. I mention that partly because it indicates that we need to think about the relationship between hate speech and what people need as they go about their business or raise their family or just participate in the ordinary social life of a community. People need some assurance that they're going to be treated as folks with the ordinary status of an ordinary citizen, that they're going to be treated as having a particular status as a person in good standing in the community, that they are going to be permitted to go about their business in a way that allows for the ordinary business of life to be conducted in an atmosphere free of hostility specifically directed against them. Some of my time at NYU, I'm a moral philosopher, and I teach a course on human dignity. And sometimes I say that this is an attempt to safeguard the dignity, not the sort of great Kantian metaphysical aura of moral dignity, but the dignity that people have as ordinary citizens, that people have an assurance of, that they can go about their business, raise their families without facing the constant threat of humiliation and hostility. And sometimes it's important that that dignity be maintained in general, so that people can, as it were, walk the streets and conduct their business in an atmosphere free of the slanders and libels and defamation and assaults on dignity that are associated with stirring up of racial hatred or religious hatred. But also insisting that in the particular settings that I've been talking about, the campus setting, the workplace setting, the church setting, that people's dignity as worshippers, dignity as students and faculty, dignity as employees in a business setting, that dignity is safeguarded. Not just safeguarded in the sense that people are given constant reinforcement. Yeah, you're welcome here, you are one of us, but rather that nothing is done effectively to besmirch the basis or to revile or insult or undermine the basis on which people conduct their business and go about their lives in a social setting. So I think it's important to understand that the point of hate speech regulation is to provide for everybody playing their part in the establishment of this general atmosphere of assurance and this general atmosphere of respect for the elementary reputation of each person. Now, the idea there is that a group going about its business can be slandered and reviled as thieves or killers or people who are guilty of particular crimes because of their group membership. And there may be a case where that happens once and it doesn't have much of an effect. It happens 2 or 3 times and it begins to have an effect and change the atmospherics in a society. So one way of thinking about hate speech legislation is that it is a basis on which we maintain the social environment. It's almost like an environmental protection law. We know that you can have an incident of hate speech that doesn't constitute a true threat, or it doesn't constitute fighting words. But you know that that incident and this other incident can begin to add up to a slow-acting poison in the community that makes it much, much harder for people to live their lives, conduct their business, raise their families in a community like this. So in a way, a hate speech body of legislation is a little bit like a protective basis for that environmental value. I do think it's important to understand all of this and to see that those who go about the business of maintaining hate speech legislation, they still have to face the hard questions that Nico raised. I concede that immediately. Those hard questions are raised by innumerable, or similarly hard questions are raised by innumerable laws that we have to deal with. And we are worried about abuse. And we know there have been cases of abuse, and Nico mentioned a couple of them. But this business of trying to make sure that people can live their lives, raise their families, and go about their business free from the group defamation or group-based defamation that might afflict them simply on the basis of their character, that seems to me to be a reasonable aim for public policy. I think, for example, in Great Britain, in the 1960s, when their hate speech provisions were first introduced, the UK was facing a large influx of immigrants. And the members of the government began to think, how are we going to ensure that the people of the community generally play their part in maintaining an atmosphere where the immigrants are made to feel welcome? And it was thought that having some prohibitions on the more egregious forms of hate speech, defamation of immigrants, reviling them, casting aspersions on their ability to be good citizens, was something that was important to keep the peace and maintain the possibility of bringing people into a hospitable environment. So that's basically what I wanted to say. I want us mostly to understand that hate speech is a difficult solution to a difficult problem. And so the difficulties can easily be exaggerated, but even if they're not exaggerated, hate speech is supposed to be a thoughtful solution to a problem that requires some degree of thought to discern. And so I'm very grateful to Nico for having raised the issues of thought. I wanted just to set out this basic architecture of hate speech legislation. It differs from society to society. And the point here, as I said, is not to persuade you necessarily to reverse your votes in the poll question or anything like that. Because even if we want to maintain the status of hate speech as protected speech under the First Amendment, and even if we want to try to confront the focused issues that I talked about using that combination of positions, it is well that we understand the case that can be said for the other side. It does us no harm to understand what the Germans or the British or the New Zealanders or the Canadians or the Israelis or the French are getting at when they set up their hate speech legislation, to understand the structure and to understand the purpose that they're trying to achieve. So thank you very much indeed.
This is great. I'm going to give you a chance to respond, and for you to respond to the response, and then I have some questions.
Yeah, there are, I guess, a couple of points that I wanted to raise in response to your excellent introduction there. You cited, for example, one clause to a hate speech code. I think it was like a religious tolerance code of some sort. And that clause said that nothing in this law should apply to the expression of opinion or belief or what have you. That it shouldn't infringe upon free expression. We have these clauses that are applied to laws all the time here in the United States. They're called savings clauses. The idea is that the law could be read to violate free speech rights, but we're going to put this thing at the end of the law that says it can't violate free speech rights. Courts, more often than not, overlook this in trying to assess these laws. These clauses are often put in to laws that the drafters know violate the First Amendment. The other question is about discretion in applying these laws. I don't place much trust in prosecutorial discretion. I think President Trump has a specific view of the Department of Justice, and if they're bringing prosecutions, I'm concerned that it might be seen as a political arm of his desires, so to speak. Currently, my organization, the Foundation for Individual Rights and Expression, is representing a pollster from Iowa named Ann Seltzer. She had put out a poll ahead of the election that showed Kamala Harris winning by 3 points. Turns out Donald Trump ended up winning by 13 points. She was wrong. She ate crow. She has a long storied career, often predicting outcomes to elections that nobody had predicted. She predicted the outcome of Trump's elections in 2016, for example. But nevertheless, Trump is suing her for consumer fraud, the idea that her poll is a form of fraud. So I do worry about how those in power with axes to grind can use laws that, admittedly have nothing to do with speech, like consumer fraud. These deal with things often like the used car salesman who rolls back the odometer on the car, not someone who's putting out a political prediction. But I do have concerns that if there were a hate speech code, for example, at the federal level, how would the Justice Department implement it in a world where you have a executive with an axe to grind? On the defamation front, in the United States, there's a high bar for defamation. Usually when it's discussed with regard to public figures, it needs to be actual malice or gross disregard for the truth that is the standard for successfully bringing some of those claims. But I think, Professor Waldron, you have a broader definition of defamation, something you would like to see implemented. And in your book, you talk about how group defamation might even apply to someone criticizing the Tea Party, alleging that it misuses public funds or is dishonest. I would argue that that's core political speech, and it would be a big concern of mine if that were brought under the defamation category of speech accepted from the First Amendment. On the dignity point, I think the ability for each and every one of us to be who we are and to speak our minds is essential to our human dignity. So you have claims of dignity on both sides of this argument. And then the last point I'd like to make is with regard to political reality. If you're at a point where you can marshal a majority to implement a hate speech code, then the environment that you live in, I believe, is conducive to giving you the sort of assurance and dignity that you so desire. You're never going to get a hate speech code in the South in the 1930s and 40s because you can't marshal a political majority to implement it. And at the start of Professor Waldron's book, he talks about a theoretical Muslim man and his son walking through their neighborhood with signs that say Muslims go home. I'd argue that in our society today, if you were to see those signs, you would see vociferous protests against those signs. The person who put up that sign would be likely a subject of cancel culture. They would lose their job. I witnessed many of these protests in the wake of the so-called Muslim ban in the first year of Trump's presidency, right? Not signs that say Muslims go home, but the allegation that Muslims should actually go home. And you had protests within the airport, Dulles Airport, the airport I went to fly here today, that were protesting these actions. So I think in any universe where you can actually marshal a majority to pass a hate speech code, you're going to have other powers within society that would push back against hate using counter speech.
That's it. Yeah. Thank you very much, Nico. Should I respond to some of those points? Because I think they're all excellent points. One thing that worries me is this general doubt about prosecutorial discretion. Now, prosecutorial discretion can be understood, first of all, in its relationship to the legislation that supposedly frames the discretion, sure, and the vocabulary that's used. And we face these problems of drafting all the time. And there's no doubt that existing hate speech laws in the various jurisdictions that we've been discussing could be better drafted, could be better used. Not because they use words that we're a little bit unfamiliar with, like group defamation or reviling or stirring up hatred, but just because we're waiting to see how the jurisprudence begins to accumulate around those things. But if we start taking a generalized suspicion of prosecutorial discretion, then there's going to be a great difficulty about how much regulative activity we can engage in anywhere, not just hate speech, but all sorts of other problems. So I would beg you to take that into consideration with this otherwise rather free-ranging skepticism that you evince.
It's in the context of speech where you have vague statutes, but yes.
Yeah, I know, but you have vague statutes everywhere. John Stuart Mill once said, look, a particular principle, I think he was thinking of the harm principle, it won't work if we suppose universal idiocy to be conjoined with its application. We need to imagine people of good faith would try to set up. So one of the things that it's useful to do is to bear in mind everything that Nico said about the possibility that these hate speech regulations will be abused, but nevertheless to entertain for ourselves what a good hate speech code would look like and what a good framework for that discretion would amount to. So it seems to me that that's worth considering. On the question of libel and the high bar for defaming public figures, I'm reminded that when John Paul Stevens, Justice Stevens, reviewed my book, The Harm and Hate Speech, he made the suggestion that even though ordinary people are the ones getting defamed when hate speech is directed at a community of persons within the society, nevertheless, the group itself might be seen as a public figure, and therefore the group itself would, and that seemed to me just sophistry, an attempt to avoid. Listen, we know that there was a time in the United States 50 years ago, 60 years ago, when people were concerned about group defamation, and this was the category of thought that was used to try to regulate hate speech. There still is something called the Jewish Anti-Defamation League, which is partly a legacy of this period. There were clinics set up at Columbia Law School and other law schools to try to draft group defamation laws or model group defamation statutes. There was a case, Beauharnais against Illinois, where the Supreme Court upheld a hate speech regulation in Chicago, and upheld it on the specific basis that it involved defamation of the African American community in Chicago. So people have used this notion of group defamation, trying to think their way through this problem. And that's what I see the purpose of our gathering here today, to think about the various pathways of thought that we might follow. Finally, just mischievously to respond to the point that you made about dignity, Nico. Yeah? You said, sure, but expressing your opinion and having the right to express your opinion, by God, that's part of a person's dignity as well. And you're absolutely right about that. And dignity is one of those concepts that is often going to feature on both sides of a given issue. When it features on both sides of a given issue, that doesn't end the argument. That just poses a particular challenge to the pathway of thought that we're following. We have to ask ourselves, so do the claims of dignity need to pull back a little bit on both sides? Is this one of those cases where the dignity on one side trumps the dignity on the other side? Or does it show that we're dealing with a genuine, troubling case of some sort of tragic conflict of values, which can't be gainsaid by either side in the debate? But what I would not use this point to make is just to dismiss out of hand the fact that we can't. And the fact that dignity is involved in a speech claim doesn't mean that dignity is not also involved in responding to a hatred claim. And we have to attend to both sides of that question and try to figure out how to deal with the tension and the difficulty between them. So those are just responses to a few of the excellent points that Nico made.
Thank you.
All right, this is great and really wonderful, and you've opened up, importantly, some of the value space here that's sometimes not front and center in debates about free speech, particularly the dignity aspect. And people do think about, is there a tension between civil rights and civil liberties? Is there a tension between norms of inclusion and respect and norms about free expression? I want to ask, and I think, Jeremy, this is mostly to you, there is an old line that the best way to fight bad speech or hate speech is with more speech. And Nico kind of pushed on this when he said, look, here's a way you could respond to defamation by somebody. The community could rally, right, and come forward. And in fact, isn't that a better response than having the state simply pass a law where the community doesn't come out and own this as, that we make the space where the world happens, and we have a responsibility. And given the dangers of state overreach, why wouldn't more speech just be the answer here?
More speech is the answer. It's certainly going to be part of the answer. I mean, I don't see it as an either or. It may well be that more speech is the first best response, but that we need other things to do as well. It may mean also that we need law to play a role in shepherding and pushing forward the role of more speech. People sometimes say that law has an expressive function as well as a coercive function. And I think here, hate speech laws where they exist often perform an important, we say, chilling or expressive function. Sometimes the function is to just slow people down, make people think twice before they particularly phrase a piece of hate speech in a particular way. Sometimes it's important for the members of the community who gather in exactly the situation that Nico was talking about and that you're alluding to understand that they are expressing values that the community has already committed itself to. So I think all of these possibilities can be in action, and I think it's a mistake to assume that the best way to fight hate speech is more speech in every circumstance. It may be the first best or the second best or one of a number of strategies that should be used.
One point I think I would make is that it goes back to the democratic legitimacy argument that I was making, or at least briefing there at the top of my opening remarks. To summarize it again, is that people can only trust the outcome of a process if they believe the process itself is fair. So, for example, if you live in a society with kangaroo courts, you're not going to trust the outcome of any jury verdict because you think that the verdict was in before the jury even had an opportunity to deliberate. And I think in the democratic process as well, people can trust the outcome of the democratic process if they believe they had a voice in the process, if they believe all arguments were allowed to be put forward. And one of the reasons I think we have declining trust in our public health institutions in the wake of COVID is that there are some people, correctly or incorrectly, who believe that there were certain arguments that weren't able to be put forth during that debate. And so they no longer trust vaccines, for example. All you have to do is look at the vaccination rate across the country for things like polio and measles, not just COVID, to know that people, for whatever reason, are not trusting the outcomes of those debates. They're not trusting vaccines anymore. And I think this can be applied to hate speech as well. If you have a debate in your country about immigration, and you have some people who go out there and say Muslims go home, or they approach that debate in admittedly hateful or intemperate ways, you risk, I think, undermining the democratic legitimacy and risk people not trusting the process anymore. If we had brought one of these hate speech codes down on Donald Trump when he said that immigrants are poisoning the blood of our country, can you imagine the democratic backlash that would come from his supporters after that? Now, maybe you think it's something that should exist anyway. I see Professor Waldron going, yeah, maybe. But I think one of the reasons you have so much backlash in European countries and the United Kingdom to immigration is that people felt like they couldn't speak up on some immigration issues. So I do worry that hate speech laws applied and abused do risk undermining democratic legitimacy.
Sure. So the democratic legitimacy argument is an important one. There's no doubt about it. And we have to strive to make sure that the democratic process is fair, to use the term that Nico used, and inclusive of as many of the opinions as are held in the community as possible. That's why some of the provisions within hate speech legislation about mild or moderate versions of the problematic opinions may actually seem to be more important than you were suggesting. That is, we want to find, we say to everybody, if we're going to have a fair debate about whether it's vaccination or immigration or affirmative action or race relations, then you have a responsibility to find a way of expressing your opinions that doesn't fall foul of these particularly hedged around hate speech pieces of legislation. Now, that's why I thought it was important to bring the architecture to the attention of us all here today, that the architecture of the structure of these hate speech laws is designed at the same time as it discourages the hateful rhetoric. It's also designed to afford opportunities for people to rethink the particular opinions that they want to hold. Now, no political process is going to include all opinions that people have. Some of the opinions will be libelous, even given the bar that you talked about, and some of the opinions will be violations of national security requirements. Some of the opinions will be fraudulent in various ways. We have to bend over backwards to see if we can maintain the goods that hate speech legislation is aiming at, while at the same time ensuring that we have an inclusive and fair process. And I'm not saying that's easy. What I'm saying is we don't simply flinch away from the task as soon as we find out the possibility of a difficulty here.
Yeah, the Supreme Court has dealt with these questions of the ways in which someone expresses themselves before. The famous case, Cohen v. California, where a man wore a fuck the draft jacket into a courtroom. The court ruled that one man's vulgarity is another's lyric. I do worry about the sort of paternalism that comes from hate speech codes. It's like my mom used to say, young man, watch your tone. Now we have the government saying, young man, watch your tone. So there's just there's just a vagueness that comes by the nature of these codes. To make it concrete, and maybe this is a segue into the current controversies, from the river to the sea, Palestine will be free. Hate speech? Some people certainly think so. Some people think that's a call for genocide. We can look at the congressional testimonies in December of 2023 to see an example of certain people who believe that's a call for genocide. Other people believe it's a political statement. So I worry about the sort of tone policing. Yes, you can make certain arguments, but only in certain ways, and the paternalism that comes with that, and the ripeness that for abuse that comes with that.
So I wonder if we could use a particular example and bring it to the campus in Title VI.
Yeah.
So Title VI, and this is something which not everybody in the class may know, the Supreme Court has in effect said, and the two of you can correct me if I have it somewhat wrong, that discriminatory harassment can be punished, and discriminatory harassment is in effect hate speech of a magnitude or a sort that deprives people of the ability to pursue their education on campus. So I have a question for, some of it's for both of you, I guess. One is, that's pretty vague. The mere fact that the Supreme Court said it doesn't mean that it's a good standard. Maybe that's too permissive of legislation. Maybe it's not. I'd like you to address that. But also, is the campus a special place? So much of the litigation that has led to First Amendment doctrine takes place in large public spaces. The university might be thought to be special in some ways because of its educational mission. Universities like Stanford, less so Columbia and NYU, which have residential campuses, students live here and their dignity is connected with their living here. So how do you think, and by the way, there's no attorney general, it's the provost's office who decides who to prosecute, although there's the attorney general or the Department of Education is there somewhat in the background because of, with the threat, vague or more specific, that if the university does not enforce that kind of hate speech regulation, they may lose their federal funding. So how do the two of you address the issue of discriminatory harassment, hate speech in the university context?
Yeah, I can start first. So the Civil Rights Act of 1964, people are most familiar, I think, with Title IX that bars sex discrimination in higher educational institutions that receive federal funds. That last part is important. We think of it in the context of sports, for example, but it has also implicated things like sexual misconduct on campus, for example. But there's also Title VI, which bars discrimination based on race, color, and national origin. Now, it's been interpreted to also apply to shared ancestry and ethnicity. That's what raises these debates about anti-Semitism, for example, because it's that interpretation that allows it to apply to allegations of anti-Semitism. FIRE has long supported what we believe is the standard that the Supreme Court has articulated for what speech constitutes discrimination on a college campus. And this comes from a 1999 Supreme Court case called Davis v. Monroe County. Granted, it deals with K through 12 education, not higher education, but we don't have a good case on point from the Supreme Court. And it says that the conduct must be so severe, pervasive, and objectively offensive that it effectively denies a student the right to the education. Now, the Office for Civil Rights of the Department of Education has slyly and disingenuously, in my opinion, articulated a standard that is severe, pervasive, or objectively offensive, So it doesn't need to meet all three criteria in order to be speech that would be unprotected. It just needs to meet one of those. And this is what we believe has created an environment that is ripe for abuse on college campuses, where someone says one statement that is severe and the university risks losing its federal funds under Title VI or Title IX. This is what raises the question about, for example, from the river to the sea. Is that one statement severe enough that it constitutes a Title VI violation? I don't know. But under FIRE's standard, and what we believe the Supreme Court has already articulated, that conduct is so severe, pervasive, and objectively offensive that one-off statement would not constitute unlawful discrimination. Now, it might constitute unlawful discrimination if it's shouted while by someone who's trailing a Jewish student, for example, or shouted outside of their dorm room repeatedly, for example. It's a pattern of conduct, which gets closer to the conduct or action concept that I was talking about before. So I think I'll leave it there, and I'm sure we'll dive into it some more.
Right. Right. I mean, I think that's exactly the approach to take, is to look at the patterns of action and look at what they add up to, look at what they are in themselves, and look at what the predicament of the targeted group is when all of these actions, the whole pattern of these actions is taken into account. But let me say something with my jurisprudence hat on a little bit here too. Listen, we can be frightened away from legislation by the prospect of vagueness. And vagueness covers a multiplicity of sins. And sometimes what it is it's an invitation to a legal community to be a little bit more thoughtful and to be a little bit more open in the reasoning that they bring to a particular problem. So discriminatory harassment may be a vague expression, but it invites us to develop and to put into play various possible understandings of that, and to use that opportunity afforded by the vagueness to make our law more thoughtful and make the reasoning behind it more transparent. So I do want to just insist, and it's part of being like a broken record this afternoon in my responses to Nico, but also in response to Paul's comments, that we have to be very, very careful that we don't throw away all the tools that a good legislator might use, which will include language that invites people to give some thought to an issue, particularly when we imagine that some of the language is going to be parsed by judicial institutions as well as by prosecutors exercising their discretion. Final point about from the river to the sea, Palestine will be free. It is a vague expression. It's a different sort of vagueness now, vague chanting. But we know that that can be read as anti-Semitic. We know that it is chanted by people who know that it can be read as anti-Semitic. We know that it is chanted by people who seem to be indifferent to whether it is read as anti-Semitic. They think it is both legible as anti-Semitic and deniable as anti-Semitic. And I think we need to plumb all of those dimensions of its status before we say that there is some affront to free speech in banning that particular chant, particularly when it is a chant used implacably, as chanting always is, to stop people concentrating, to make them feel excluded, and to intimidate them, frankly. Yeah. So we have to take all of this into account. We have to look at the complex psychological reality of the particular interactions that we're talking about, and do that under the auspices of this standard in Title VI that requires us to pay attention to the development of a hostile environment in an educational institution.
Can I make another point? Which is, I want to go back to that congressional.
And I'm going to open it up for questions from the audience.
Wonderful. I want to go back to that congressional hearing in December of 2023. I think you'll all recall the presidents of MIT, Harvard, and Penn testified in front of Congress, and there was debate around this question, from the river to the sea, Palestine will be free, and it was almost taken for granted, it seemed, in that hearing by the congressmen and women, that it was an example of anti-Semitism and it was a call for Jewish genocide. And they asked the presidents whether calls for Jewish genocide are banned on their campus. And all the presidents said, well, context matters. I think they were right. I think you need, anytime you're talking about categories of unprotected speech, you need to look at the full context of the statements. And I recall in that case, again, calls for Jewish genocide were being paired with from the river to the sea, Palestine will be free. But even calls for genocide amorphously, to ban them, I mean, at that time, it was seen that those supporting the Palestinians were calling for a Jewish genocide. But now you're seeing allegations that anyone who supports the war in Israel is supporting the genocide against Gazans. You're seeing people who support abortion being alleged to that genocide, that they're committing a genocide against the unborn, or people who oppose gender-affirming care are committing a genocide against the trans community. This idea of genocide can be wielded by political opponents against one another. So context always matters. And right now you see movements within Congress to adopt what's called the International Holocaust Remembrance Association's definition of anti-Semitism, to make it clearer for folks what anti-Semitism actually is. And my organization, FIRE, has opposed this because as part of the definition of anti-Semitism. It says, contemporary examples of anti-Semitism in public life, the media, schools, the workplace, and in the religious sphere could, taking into account the overall context, include but are not limited to, and then it lays out 10 different arguments that might be considered anti-Semitic, including denying the Jewish people their right to self-determination by claiming that the existence of the state of Israel is a racist endeavor, applying double standards by requiring of it a behavior not expected or demanded of any other democratic nation, and drawing comparisons of contemporary Israeli policy to that of the Nazis. They also allege that holding all Jews responsible for Israeli policy can be an example of anti-Semitism. But then I look at these arguments, and it seems like the policy violates itself. Drawing comparisons of contemporary Israeli policy to that of the Nazis, it's saying that Jews, it's an example of anti-Semitism to criticize Israel. So we have to be careful, even when you're trying to draw careful lines around these policies by laying out specific arguments. You could also get into overbreadth and vagueness challenges.
A lot more to say on this, but I'd like to open it up to the audience. So please come to the mics. We have 2 mics to ask questions.
Don't be shy.
Hi, I think I'm the only person up right now. Period. My name is Puali'i. I'm from Hawaii. I have like a different question for each of you, if that's okay. They're like pretty short. For you, Mr. Waldron, also thank you for your talks, and this is really interesting. I still don't have a decision either way. My question is, you said that hate speech is calculated as intended to stir up hate. And my question is, what if this hate is directed toward an oppressor? I'll give an example, since you said you're from Aotearoa. As a Hawaiian person myself, Hana Rafiti and other committee members did a haka in Parliament in support of Te Tiriti o Waitangi, and I do think that that could and has been considered a form of hate speech, has even been considered demonic. So my question is, like, how do you navigate hate toward an oppressor or a racially oppressive group? And then my question for Mr. Perino is, do we prosecute threats only when they result in physical harms? People do get arrested and prosecuted for plans to harm before the actual harm happens all the time. For example, if a quote-unquote terrorist group was to make a plan to even assassinate Donald Trump, I think that if the FBI found that plan, that would be considered a threat, and that would be prosecuted. You also kind of get to a question of whether emotional and mental abuse are okay because they're not necessarily actual physical actions. That's just your own speech and could be definitely considered hate speech. So I guess the question is, does it have to result in physical harm for it to be considered a threat, a viable threat, or can it just be a plan that doesn't actually get carried out? So those are my 2 questions.
Yeah, I can start first. So at the top there, I said that true threats and speech integral to criminal conduct, I do think are categories of unprotected speech that the Supreme Court has already articulated that should remain unprotected categories of speech. Now, of course, you have line drawing there as well. There was a famous Supreme Court case called Watts where a man said, if I ever get my draft card, Lyndon Baines Johnson is going to be in my gun's crosshairs, for example. And the Supreme Court held that that wasn't a true threat because it was kind of this amorphous claim, and it was political hyperbole. But generally, for something to be a true threat, there needs to be some sort of imminence associated with it and some credibility associated with it. But I do agree. I mean, this is speech, but it's speech that, based on a high bar, is eventually going to lead to some level of criminal conduct. And was there a second part to your question?
For example, emotional and mental abuse, right? Like that, it can be prosecuted, like say parental negligence or emotional abuse towards a child, but that could be just yelling and screaming at a person, which could be just considered speech and not action.
Yeah, well, with children, the law is always very different, and I think the law should be different. But there was this woman, Lisa Feldman Barrett, I believe she's a psychologist, who wrote an article in the New York Times back in 2017, if I have my years correct, who made the argument that speech can sometimes be itself violence. And she talked about how speech can cause chronic stress, which can lead to the shrinking of telomeres in your chromosomes, and as a result, speech can be violence. I thought that was a little too cute by half. I mean, if I have an ongoing argument with my wife, that might cause chronic stress. I don't think the argument itself is violence. So I think we need to be very careful where we are arguing that disagreement, chronic stress should lead to some sort of exception to the First Amendment. But I agree, abuse, particularly child abuse, might be an exception to that.
Even if it's like not a child, though, there's still. Oh, sorry.
We have a lot of people.
Yeah, let me just respond to this extremely interesting question that you asked first of me, which is, what about situations where the hate speech is directed at stirring up hatred against an oppressor, as opposed to just a particular part of the population? And my first thought when you said that was, well, hang on, that's easy. The laws just insist that the hatred has to be directed, the hatred that's stirred up has to be directed at a particular section of our population, not particular individual oppressor figures. And I thought that I could dismiss the question that easily, but I can't, because we have to consider the possibility that a society may objectively have enemies. And some question would be, are we going to take a different attitude, a less protective attitude, towards people who are of the same ethnicity as the oppressors that we're struggling against in some situation? So, for example, the Russians invaded Ukraine. Now, how is that going to affect how we deal with or protect Russian Americans in their dealings with the rest of the population? And like everything else in this debate, it's a difficult question. The normal worry is that you can respond to oppression without necessarily stirring up hatred against them. You can respond to oppression without necessarily having to revile or insult a group. So sometimes the adverbs will help us with this particular one. But I agree with you. It's a conundrum if you imagine the possibility that we live in a hostile world where there are enemies of various sorts. We need to be aware of the grim prospect of Korematsu hanging over our heads on this, that an internment policy designed against the people who had something ethnically in common with an aggressor might lead us to make decisions that we regret later in the way of dealing with that perceived threat.
Thank you.
Hi, thank you. My question is for both speakers. I was curious about sort of your ideas about how the purpose of institutions, whether that's a country or a university, may determine or affect the appropriate speech codes, and just sort of, I guess your thoughts on how the goal of an institution may lead to potentially different speech codes that are most appropriate for achieving those ends.
Yeah. So I go into a courtroom and start shouting out my true opinions in a non-threatening but nevertheless noisy way. And the judge will tell me to shut up and perhaps convict me of contempt. And he will mention the purpose of the institution that's being protected from my intervention in this way, that it is to have the most civil and regimented presentation of views from people who are admittedly very hostile to one another. So in that case, in order to show that a courtroom would be a different sort of setting for speech, we need to pay attention to the point of having courtrooms and the point of structuring them in particular ways. I believe we have to do something the same with universities. That universities are places where we pursue learning and public debate in all sorts of ways. I'm not saying it's the same as the courtroom, but it's not the same as the ordinary streets either. So I do believe that as well as our general thought about hate speech, we have to give some thought to these particular settings, which was one of the things that I wanted to insist on in my initial comments.
Yeah, the courtroom's interesting. Often free speech advocates will use truth as the reason that they support free speech, that in an environment where free speech is allowed to happen, you're more likely to arrive at the truth. I think that's more true than it's not, but it's not the argument that I always rest my case on, in part because of the courtrooms, particularly here in the United States, where the purpose of the court is to arrive at the truth, and it's a highly regimented speech environment. Now, I don't think this is highly regimented speech environment should be expanded beyond the courtroom just because it happens to work at finding the truth in the courts, because there are other considerations such as individual autonomy, for example. But it does speak to, for example, the purpose of any institution being able to carve out guardrails around what can and can't be said. I believe that the purpose of a college or university is the preservation, dissemination, and creation of knowledge, and I do believe that free speech and academic freedom are essential for that. You see other places that are public expressive institutions, for example, like libraries and museums, that I think should have more free speech than other institutions, for example, but each institution is going to determine its purpose in its own way and how free speech might play into it.
Thank you both for this really insightful discussion. My question is mainly for Mr. Perino. A lot of your arguments come from this epistemological problem, that it's hard to know and define, even within the law, what hate speech is. And I think these are great arguments, they're very compelling. But my question is, let's say this epistemological problem went away and we could actually define what is hateful speech and what isn't. And so then we would no longer have the problem of prosecutorial discretion. Let's say hypothetically, I realize this is very improbable.
Sure.
But if that were the case, would you still think that hate speech should be constitutionally protected?
It's a fantastic question, and in short, no, in part for some of the reasons that I laid out at the top of my opening remarks. But again, I believe that free expression, even the ability to express hateful and vile opinions, is essential to human autonomy, the right to be who we are and to speak our minds. I think it's essential for democratic legitimacy that I was talking about before. And I also believe that it's important to know, again, the world as it actually is. My colleague Harvey Silverglate, a Jewish man, says, I want to know who the Nazi is in the room so I know not to turn my back to them. If we have a racism problem in this country, we do ourselves little service by shutting up all the racists. It doesn't make the racists go away. They just harbor it in different ways, and it might manifest in itself in more discriminatory and more harmful ways. I think you want to know who the racists are, so you know whose minds you need to change, and you know who not to turn your back to. It's often called the informational theory of free expression. It's good to know the world as it actually is.
My question is also for Nico, and he kind of talked about this earlier, but I'm curious where you draw the line between hate speech and harassment. Like, because obviously you're very pro free speech, but like, what do you consider like goes into harassment? Like, if a bunch of anti-Semites rally outside a Jewish daycare school and shout anti-Semitic slogans, would you say that falls under free speech or harassment?
Not very sympathetic, but I'll take the example as it is. I'd say if it's just a rally outside in a public space outside of a Jewish day school, it's protected speech. For me, the line between protected speech and unprotected harassment would be, again, I think the Davis court got it correct when they say it's conduct that is so severe, pervasive, and objectively offensive that in the educational context it denies someone the right to their education. I would need to look at the harassment codes outside of the educational context to see whether I agree with those. But it needs to be a pattern of conduct. It can't just be offensive speech. And Professor Waldron had talked about the Snyder v. Phelps case. This was a case where the Westboro Baptist Church had signs that said horrible things outside the funeral of a dead soldier. Yeah. Yes, and this the code that was used to prosecute them, I believe, was a code relating to intentional infliction of emotional distress. And the Supreme Court held this to be protected speech. And I think rightfully so, because I think this is core expression of opinion in a public space. And again, I worry about tone policing.
So you're not, sorry, just to follow up on this, you're not sympathetic then, so the Stanford had a speech code, which was an attempt to be very narrowly tailored. And the narrow tailoring was that it was the demeaning, insulting language, but it was to somebody's face. So it was on the analogy, this was drafted by Tom Gray, and it was on the analogy of fighting words.
Yes, yeah.
That, and from what I'm hearing, you're not sympathetic. I mean, maybe neither of you is sympathetic to that. I'm not sure that for you, that piece, that was an attempt to really deal with the worries about the overexpansiveness and the misuse, but to actually to tie it and hone it closer to harassment.
Right. I mean, the to the face and the connection of that with fighting words, I think that's an important thing to take into account, but I can't see that it can be the be-all and end-all. Because one of the things that we're worried about, those of us who are concerned about hate speech, leave aside the issues that it gives rise to, is the poisoning of the environment more generally. And that happens when racist or other forms of hate speech are hurled into the air, even if they're not in the immediate hearing of the people who are the targets of the racism. Because the point of the speech is to stir up hatred in the minds of the people who hear it, not the people who are the targets of it. And so, although we need to be concerned with the dynamics, the interpersonal dynamics of fighting words, we need to be concerned with this aspect of it as well. They're not mutually exclusive.
So fighting words is an exception to the First Amendment, at least theoretically, that arrives out of I believe it's a 1942 Supreme Court case, Chaplinsky v. New Hampshire, that involved a Jehovah's Witness who was proselytizing, and it had a mob set upon him. The police arrive, and the police targets and removes the Jehovah's Witness and not the mob. And the Jehovah's Witness calls the police officer allegedly fascist and a goddamn racketeer. Now, I say allegedly because the Jehovah's Witness says, I will never use God's name in vain. That's not what I said. But I think everyone agrees that he called the police officer a fascist and a racketeer. And those, the court held, were examples of fighting words. The court has really never upheld that standard in the years since. And I think mere expression of opinion to someone's face, even vile, very offensive, might lead someone to respond with fisticuffs, needs to be protected, because I believe ultimately that you can't base speech restrictions on the response of a listener. I think if you have speech restrictions that are based on the responses of listeners, then that's a very easy way to erode free speech. For example, Frederick Douglass, 1860, gave a speech and was beset, it was a pro-abolitionist speech, it was beset by an angry mob in Boston. The police came and shut down the entire speech. It's called the heckler's veto. He later gave a speech that was called a plea for free speech in Boston, in which he said the rights of the speakers is twofold, or the free speech is twofold. It involves the right of the speaker and the right of the listener. But I don't love any standard that just bases its exception on the listener. And so the Stanford Speech Code from the 1990s, for example, I didn't see that it needed to be directed to the person in person. I've got the court case in front of me, and this is just the retelling from the judge. Personal vilification that is intended to insult or stigmatize an individual or a small number of individuals on the basis of their sex, race, color, handicap, religion, sexual orientation, or ethnic origin, and is addressed directly to the individual or individuals whom it insults or stigmatizes. I don't know if addressed directly means it has to be in their face, or it could be a nasty email. I don't know. But the court ended up striking this one down. And it wasn't appealed, I guess.
It was not appealed.
Yeah.
Thank you both. I have a question for Dr. Waldron. As I understood you when you were giving your opening remarks, you said that the main incentive for banning hate speech is to preempt any kind of harassment or discrimination or violence against a specific group of people or some people. Why not just punish the act of harassment or violence or discrimination itself, where that might be more clearly, obviously illegal?
Yeah. No, it's a perfectly good question. And somebody would say, look, the job of the law is to stop the violence and discrimination when it happens, rather than stop the people who are calling for it. The fact is, we haven't got enough police to stop that, to stop the violence and the harassment and the discrimination when it happens. If it is a situation where that violence and discrimination is getting out of hand, we have to be concerned with the social dynamics that are framing a context in which that happens, and we have to be concerned with everybody having some responsibility to play their part in maintaining a non-discriminatory atmosphere and a non-violent atmosphere. So I understand we can say, look, this is just the job of the courts and we shouldn't be enlisted by hate speech laws into keeping the tone down or keeping the discourse civil or reasonable. I think that doesn't really convey how law works. It doesn't take care of the importance of the expressive function of law as well. So just for those reasons, I would pay attention to the fact that, look, laws of all sorts, including anti-discrimination laws, require people to self-apply the laws, to give some thought in their own conduct about the application of the laws, and to mold, moderate, monitor their own conduct in ways that bears in mind the aims and the purposes of the laws, even those laws that deal more directly with the misconduct. So I think you put your finger on the right issue, which is hate speech laws are in fact insisting that people have a part to play in maintaining an atmosphere free of discrimination and free of violence.
Thank you.
Hello, this question is for Mr. Perino. From the audience, it seems to be that you are in favor of a sort of free market approach as opposed to enforcing laws surrounding, like, banning hate speech, sort of letting the market take care of itself, whether it's, like a community deciding that, oh, this person has said something, we're going to either cancel or soft cancel them, basically having the ability to form their own judgment. But I feel as though we cannot rely on people to be perhaps just in their judgments. And what if, and I suppose it could be said that, okay, if, most people were rational, and taking that example that someone else had brought up with the protesters outside, if, they were adults inside, it was like a workplace or something, they could say, go about their day, living mostly normally, having not really let that hateful and, as you say, vile speech affect them, and they can go home and whatnot. And that's assuming that the majority of people perhaps are not spewing such hate speech. But if the market, the wind shifted, and say 90% of people were speaking such hateful and vile things to a certain group of people, and the market would allow such things to be very common, and I would feel like that would count as harassment. Is it not true that it's sort of the job of the government to put a check in case the market fails on situations like the one I just explained?
Yeah, it's a good question. The first point is that I think the market needs to work regardless of whether the government has a role in policing it. So I think that even if you do have hate speech codes, you still need to have vociferous counter speech as well. Otherwise, you can't really expect the assurance that I think Professor Waldron sees as necessary within any vibrant, pluralistic, democratic society. So I think if you just have the government policing hate speech, then you're going to have a problem. To kind of expand beyond that, I don't know that, I think the key question is the action, right? I think it's going to be tough to live in any society where you're a minority and there's the sort of vile speech that's espoused by 90% of the population. I would also argue in that sort of instance, you're not going to get the hate speech code to correct it, because I think the society has already gone to a field and you're not going to have majority support to pass one. I think one of the most compelling environments to look at with regard to hate speech is Weimar Germany in post-World War I, where that ultimately gave rise to Nazi Germany. And my colleague Nadine Strawson, the former president of the ACLU, herself the daughter of a Holocaust survivor, and Aryeh Neier, who wrote a passage that I think those of you in the class read, called the Weimar Problem, points to the fact that Weimar Germany allowed for political violence to fester. And this allowed for the rise of Nazism. Weimar Germany had hate speech codes. People forget that Hitler was banned from speaking in Bavaria for, I think, 2 or 3 years. And Joseph Goebbels, his propaganda minister, made hay out of this, put up flyers across the country that said, 1 man among 2 billion is not allowed to speak in Germany. 2 billion people in the world at the time. So they turned Hitler essentially into a martyr. And I think that's an argument that we haven't really gotten into as well, is that these hate speech codes create a Streisand effect, that they have a way of elevating the speaker. But I think in an environment where you have trust in the government to crack down on political violence, to ensure that these vile opinions never turn into actual action, is the way to address the problem, not the policing of speech in a way that I think, as I've articulated throughout our talk today, opens itself up to abuse, opens it itself up to be targeting that very minority that you're seeking to protect. And that's particularly a problem in an environment where you have 90% of the population that's opposed to them.
Sorry, just really quickly, we have kind of created this super strong separation between hate speech and sort of the action not yet happening, like the hate speech not yet triggering like a physical assault or any physical effect on the minority group, but is not the fear of it happening and the stress and being the unease and not being able to go about your everyday life like other people can, is that not a sort of physical effect on the minority group?
It's certainly an effect on the minority group, and it seems to me it ill behoves us to dismiss it simply because it doesn't have an immediate violent physical manifestation. It's a real effect, and it affects the real psychology of people who are trying to go about their business, raise their family, explain to their children what's going on. Not that daddy has been beaten up. Daddy has been humiliated again and again, rebuffed again and again in this store and that store and so on. So in those cases, it seems to me you're absolutely right that it's artificial to draw this legally consequential distinction between the actions, the physical actions and interactions that are going to be classified as violence, and the atmospherics, which are generated by hate speech and which are intended to make life intolerable on a point perhaps that falls short of actual violence but raises the fear of violence, or worse still, let's not forget that it's going to raise the memory of violence. In a country like this one, which has a history of slavery, history of segregation, a history of racial terrorism, people are going to look out their window, they'll see a cross burning, and they'll say, no, not again. And so the terrifying nature of these memories being reawoken is something that also needs to be taken into account. And I would be entirely with you on that point, that we need to take very seriously the psychological effect of that and not dismiss it just because it doesn't answer to some immediate physical manifestation.
And I want to be clear, I do think there is a harm. I think this is also a country that has a history of using codes to silence dissenters. I mean, there's a reason Martin Luther King wrote his letter from a Birmingham jail. Indeed, Martin Luther King's last speech in Memphis was a speech where he was condemning what he called an illegal injunction from the court that prevented civil rights demonstrators from marching. Again, I know I probably sound like a broken record, but I don't think that any minority benefits from the erosion of individual rights, of which free speech, as Benjamin Cardozo said, is the matrix. It's the indispensable condition of every other form of freedom.
So we have 2 more questions, and I think maybe we'll take them together. And also, Kaisa, could you put up the poll?
Right, we're going to see the result.
And we don't take
the same question.
Yeah, it's the same question. We don't take the poll as, it's not about winning or losing. It's really just seeing whether the discussion moved anybody. And it's not that we even want people to move. It's that we're just curious.
We were under the impression one of us would be getting a trophy, so really very disappointed.
All right.
Hello, Professor Waldron, fellow Kiwi here, and my question is actually about New Zealand. In 2019, as you both know, there was the Christchurch mosque attacks, during which an Australian gunman killed 51 Muslims in New Zealand.
Yes.
And accompanying the attack, the gunman also live streamed it and published a 200-odd page long manifesto. But following the attack, the manifesto and the live stream have been deemed objectionable material by the New Zealand government, and anyone found in possession of them, sharing them, or downloading them, able to be prosecuted, and many have been prosecuted. I'm curious of what you guys think about that specific instance, and I guess just the broad implications of potentially restricting speech following like mass atrocities.
Right. We're answering these questions together.
Let's take the second question and then, yeah.
Okay. Mike, I've become a little fixated on the concept and definition of dignity in the argument for the hate speech codes, that they would ensure some basic human dignity. And so often indignities are written into the letter of the law, you know, here in the U.S. being 3/5 of a man, or being a woman and not having the right to vote for so long. And so it made me think, how is dignity being defined in these instances? What is dignity in this case?
Do you mind if I go first on this?
Oh, yeah, of course. You wrote about it in your book.
Well, I sort of write. I write about little else these days, because I teach a class on human dignity and I teach a class on the rule of law, and these issues all come up. But listen, dignity is a massively difficult concept to come to terms with, and at the risk of being like a broken record again, I believe that's not a reason for not using it. That's a reason for being more thoughtful about it. Secondly, it's true that we have a legal system that has been profoundly insulting to human dignity. You mentioned the 3/5 compromise, the basic upholding of slavery, the refusal for decades to concede political rights to women and so on. So these are reasons for the state has to take care to redeem itself on the dignity front. And since that is an inescapable obligation, we have no choice, those of us who are paid the big bucks to think about these things, to try and figure out what dignity means, or to try to figure out what are the pitfalls of deciding what it means. So I take your question as a challenge and as explaining why we have to live up to this challenge. Can I say something about the Christchurch Mosque murders? I mean, on a personal note, I was flying into Israel and was climbed into a taxi, and talking to the driver, and the driver said, "Where are you from?" And I said, "Well, I live in New York, but I'm originally from New Zealand." He said, "Oh, New Zealand, the mosques." And I said, "What are you saying?" And he explained to me that overnight there had been this terrorist attack in the mosques of New Zealand, in mosques in Christchurch. And then he explained to me that he wasn't going to be able to drop me at my hotel in Jerusalem because of the Jerusalem Marathon taking place along the route of that the taxi would go to the hotel. "That's all right," he said, "I will leave you at a shopping center on the outskirts of Jerusalem and come and pick you up in 2 hours to take you." And there I was in distress with a sort of barely digested news about the mosque atrocities, trying to talk my way into the shopping center past a security guard who wanted to know what was in my luggage, and wondering whether the cab driver was going to come back. So all of this resonates very powerfully with me. And to go to the specifics of your question, it's a slightly different issue from the hate speech issue. It's partly a matter of the government maintaining a determination that this man will not be glorified in any shape or form as part of its public policy obligations to maintain the conditions under which violence might be minimized. And also maintaining, I think, very strong views about public taste and good taste in the proliferation of the streaming of this particular massacre. So I think it raises questions, and Nico would have arguments, I think, about this policy. But I think we need to see how it's at one remove. It's 2 steps off to one side from the issue of hate speech. It's still important.
Yeah, my organization got involved in a situation out of Australia where there was an attack on a pastor, a stabbing, and the pastor's stabbing was live streamed I think because the church service itself was live streamed, not because the stabber live streamed their attack. And Australia demanded that that be taken off of social media. And it demanded that it be taken off social media, not just within Australia, but globally. There's a global takedown order. The idea being that Australians could use VPNs, virtual private networks, or travel abroad and see these images. So my organization got involved and
You opposed that?
we opposed it, yes. Being a free speech advocate is tough because you often have to respond to very unsympathetic examples, such as the people protesting outside of a Jewish daycare, or the live streaming or distribution of terrorist manifestos. But as a general principle, I don't know and I don't think that the sort of good taste or glorification argument should save the day. I think there is public interest in what happened, and people often, after atrocities, want to understand why it happened, if for no other reason than to understand it, than to prevent it from happening again in the future. So I wouldn't argue for a sort of, you committed a crime, therefore all your speech must be taken down and prevented from being distributed exception, no. And I should say we won that case in Australia.
Okay.
It was the E-Safety Commission in Australia.
There's a lot more to be said about these issues, but for now, please join me in thanking our two speakers. A great session. Yeah, the poll question was not the right question. It was the negative again. Because it was the should be unprotected. So I don't. We have to.
Pick the answer of your choice.
Yeah. So we don't have a good, but we don't have.